com a palavra o moderador desta mesa, senhor Jirair.
Bom dia a todos. Dou iniciado esse primeiro painel e cumprimento os integrantes da mesa e todas as autoridades aqui presentes e toda a Assembleia que aqui assistindo. E passo a palavra ao primeiro palestrante.
Senhores, muito bom dia. Eu agradeço, primeiro, o convite, eu faço na pessoa do Dr. Crico Carcelian. Agradeço ao STJ por nos ter, muito obrigado, por nos ter recebido. E, sem maiores delongas, a respeito da localização de ativos, tema de ultra relevância na Vara, inclusive na Vara de Falência e Recuperação da capital, da capital do Estado de São Paulo, no caso, a gente precisa começar a discutir alguns pontos polêmicos para envolver justamente a importância desse tema. Para que os senhores possam precisar, no processo de falência, a cada R$100, ou melhor, a cada R$100 de um ativo, antes da decretação da quebra, é localizado apenas, e esse ativo é liquidado, apenas R$15 em referência ao mesmo ativo. O que significa que temos 85% dos ativos do procedimento de falência ou desviados ou deteriorados. Esse desvio acaba tendo uma enorme repercussão, inclusive na recuperação judicial. Na recuperação judicial, dos procedimentos envolvendo grupos de empresa, que são 22% dos procedimentos distribuídos no Estado de São Paulo, desses 22, 76% indicam consolidação substancial. O que significa isso? A absoluta confusão entre pessoas jurídicas, cuja falta de distinção do patrimônio exige que todas elas sejam tratadas como uma só. Por que esse ponto acaba sendo relevante para a gente? Porque quando uma dessas pessoas jurídicas pertencentes a este grupo, com absoluta confusão patrimonial, não se encontra no Brasil e não pede recuperação judicial, caso essa falência seja decretada num primeiro momento, ou mesmo sem que a falência seja decretada, quando os credores deliberam sobre especificamente aquele plano de recuperação judicial, temos uma situação de confronto entre jurisdições. Jurisdição brasileira, que não se vê capaz de efetivamente contar com aquele ativo para tutelar os diversos credores submetidos àquele procedimento de recuperação, ou, por ocasião da falência, eventualmente, os credores trabalhistas, na maior medida, num primeiro momento, não serão satisfeitos com o desvio do patrimônio para outras jurisdições. Daqueles R$15 de ativos localizados no procedimento de falência, apenas 7 são destinados a pagar um pequeno percentual e somente dos credores trabalhistas que ficam ainda sem serem satisfeitos. E eu comento de alguns casos aqui para os senhores. Mapping, falência, 1999. Petroforte, 2001. Boi Gordo, 2004. Quanto dos credores foi pago? Uma parte dos credores trabalhistas apenas. A grande massa de credores foi absolutamente lesada. Não por coincidência, todos esses processos que eu citei para os senhores possuem procedimentos de investigação fora do país com localização de ativos. O que não tem sido simples, e aproveitando que esse painel versa, inclusive, sobre Ilhas Jersey, é algumas questões com relação à investigação desses ativos. Para que a gente possa começar, o STJ ditou na jurisprudência, a jurisprudência foi do próprio caso Petroforte, a possibilidade de contraditório diferido, que permitiu que investigássemos efetivamente, antes de ser aberto todo o contraditório, antes de ser aberta a possibilidade dessa informação, eventual desvio. Dificuldade temos tido, por outro lado, com relação a alguns pontos. Qual é a efetiva informação necessária para que o juízo brasileiro obtenha o beneficiário final no trust? Trust que não temos aqui no Brasil, pelo menos referendado pela legislação no Código Civil, mas que tem sido utilizado nos procedimentos, principalmente de insolvência, para que haja o desvio de ativos especificamente, ou a lavagem de dinheiro via investimento nacional, sem que a gente saiba quem é o beneficiário final. Mas, antes disso ainda, e eu queria, em alguns outros casos, fazer uma diferenciação que me parece importante e que não tem sido feita. Quando o caso é de desvio, me parece muito mais simples. Eu preciso identificar que aquele ativo foi, de alguma forma, ocultado para que ele seja trazido para satisfazer a massa de credores. O que tem sido feito no direito brasileiro, e aqui vale a pergunta para as outras jurisdições, é o seguinte: existe uma distinção entre extensão da falência e responsabilização daquele ente infrator. E por que eu digo isso? Porque na consolidação substancial na recuperação judicial, quando as diversas sociedades de um mesmo grupo ingressam com o pedido, e eventualmente uma fica de fora, eu posso ter uma situação que a empresa, a offshore, opera no exterior e também possui credores. Essa jurisdição internacional, e a gente não tem no Brasil ainda, a lei está tramitando, uma lei de falência transnacional. Trarei eu todos os ativos em detrimento daqueles credores quando esta empresa está em operação? Como se faz da mesma forma que a arrecadação? Ou a jurisdição de Jersey, por exemplo, vai pagar todos os clientes ou todos os credores próprios e só encaminhar o remanescente? Digo por quê? Porque no direito brasileiro, apesar da gente exigir que assim seja feito, porque o meu credor aqui precisa ser satisfeito, se fosse o contrário, não faríamos. Pela lei brasileira, o juiz brasileiro é o único, exclusivamente competente para satisfazer com o ativo aqui presente todos os credores. Por consequência, eu acabo pagando credores até menos privilegiados e apenas remeteria o dinheiro para pagamento de um trabalhista se sobrasse. A pergunta que eu deixo até, e aqui eu termino a minha exposição, é o seguinte: e se fosse o contrário, como é comum? A sociedade operadora ficaria fora do país. Os ativos são pagos e utilizados para pagar os credores de lá, ou há remessa simplesmente sem abertura de um procedimento de falência na jurisdição? Muito obrigado.
Agradecemos a exposição do Dr. Marcelo Sacramone, juiz da 2ª Vara de Recuperação e Falências de São Paulo, e como ele alertou, esclareço que o painel, esse primeiro painel trata das jurisdições de Dubai e Jersey, sendo que Jersey é uma jurisdição muito conhecida pelas autoridades brasileiras, não apenas por causa da sua estrutura de trust, como também pelo sistema financeiro com algumas peculiaridades inerentes. Em contrapartida, Dubai, jurisdição que neste seminário representa o que teríamos com relação ao Oriente Médio, tem sido vista recentemente em diversas estruturações jurídicas de investimento, e por ter essa possibilidade de relacionamento financeiro entre o Brasil e Dubai, também fará parte desse painel, sendo que ambas as jurisdições e seus relacionamentos serão expostos aqui. Para continuar, passo a palavra ao eminente Dr. Lucio Alves Angelo, Júnior, do Departamento de Patrimônio Público e Probidade.
Obrigado, desembargador. Bom dia a todos. Queria brevemente agradecer a organização do evento, do IBRA, do STJ, por estar nos recebendo de maneira tão calorosa dentro dessa casa. E queria começar também pedindo licença a todos os senhores. Estive conversando com os nossos interlocutores estrangeiros e para tomar a liberdade de formular, até para facilitar a questão de tempo, as minhas considerações em inglês, Acredito que, dado a qualificação do público, isso não vai constituir grande óbice. So, may I proceed? I believe you can take off your phones. Well, I believe my first task here is to outlining the work of the Attorney General's Office from the perspective of our anti-corruption unit in which I work currently. And I believe the first thing to highlight is that we do not deal primarily with criminal issues. Although we are structured to take part in criminal proceedings, aside our federal prosecution system, our federal prosecutors, mostly when it pertains to, when it pertains to the federal government as a victim of a crime. But our main focus is on corruption through basically 3 legal keystones. The first one concerns the disciplinary system of Brazil. We have a specific law, a statutory law in Brazil, that was made to punish and sanction our public agents here in Brazil. And sometimes it takes us and implies our second approach that regards to the Improbity Act. It's actually a very difficult task to translate it into English. It's a very peculiar legal figure we have in Brazil. But the most important thing to stress at this point is that it is a civil proceeding, mostly. So we have different standards of proof when we move those kinds of lawsuits. And in third place, I could mention our relatively recent anti-corruption legislation, which sets forth the celebration of leniency agreements. They are administrative proceedings carried out mostly by the Comptroller General's Office, and we have a formal cooperation document that establishes that the Attorney General's Office also takes part in its proceedings. And that being said, when I took a look on the other panels, I tried to connect those dots and look for similarities between public and private issues when it comes to tracing, freezing, confiscating, and finally repatriating assets. And the first thing to say is that we still need for effective cooperation in non-criminal matters around. It has been our main speech in the later years before many international courts. We don't have that tradition. We're only used to obtain cooperation when it comes to criminal offenses. Even the United Nations system and the OECD systems, they are, in our opinion, too centered on that kind of malfeasance, crime, criminal offense, and criminal proceeds. And that's a thing that we are struggling to prove, that we can obtain better results on asset recovery according to, when it comes to civil and administrative proceedings. Well, it is also a common sense that fishing expeditions are not admitted for any legal system around the world. You have to know what are the assets. You have to identify them previously before formulating any request abroad. And it is important to recognize that who has the legitimacy to act before foreign jurisdictions. It's a key issue for us as well. And it is important to say that tracing is just the first stage of that asset recovery cycle. We must repatriate things. I was talking to my new colleague, Mr. Braga, yesterday, and he asked me, well, what are we doing here if we don't bring that money back? I'm just telling my clients that I'm able to obtain a favorable judicial decision, but when is my client going to be paid? And from our perspective, my client is the federal government, is the Brazilian society, but we are facing the same issues, right? We have the same problems. And to finish this exposition, this context takes me to my final question, if you could please address that on your responses. Could you please identify the main tools within your respective legal frameworks currently available for asset tracing when requested by states or private parties, regardless the dichotomy formal versus informal process, and if possible, the ones which are related to civil and administrative proceedings? Okay, thank you.
Agradecendo a exposição do Dr. Lucio Alves, passo a palavra à eminente promotora de Justiça do Distrito Federal, doutora Danielle Martins Silva.
Muito obrigada, desembargador. Agradeço a oportunidade de estar aqui hoje. Muito obrigada ao amigo, muito querido, presidente do IBRA, o Dr. Rodrigo, que me fez este convite. E, na qualidade de promotora de justiça, eu não posso, ao ouvir essas questões que foram colocadas aqui hoje, pontuadas, da dificuldade de reaver esses bens, de que, especificamente, que as ordens judiciais relativas à repatriação, né, desses ativos alcancem os seus fins, o meu interesse é aqui saber, para fins de efetividade processual, para que essas decisões judiciais atinjam as suas finalidades, especificamente para que se opere o cumprimento de liminares que constem, eventualmente, dessas ordens judiciais, quais seriam os requisitos necessários? Há especificidades que precisariam constar dessas ordens judiciais para viabilizar ou facilitar o seu adimplemento em outras jurisdições? Uma intervenção bem rápida e bem objetiva, como, né, acho que precisa ser nesse tipo de tema. Muito obrigada.
Agradeço à doutora Danielle e passo a palavra ao eminente doutor Manuel Ângulo Lopes, administrador judicial e advogado.
Bom dia a todos. Agradeço muito a oportunidade recebida de estar aqui presente pelo presidente do IBRA, Dr. Rodrigo Garcelian. E, em relação ao tema, eu trabalho com falências, concordatas, hoje recuperações judiciais, desde 1978. Nesse período todo, em que passaram por mim, eu acredito que mais de 3.000 processos, se viu muito, não só eu, como outros colegas também atuam, desvios escancarados nos processos que nós não tínhamos, naquela época, condições de localizá-los. Hoje, em razão da internet, são bem mais fáceis de serem localizados em outros países, porque quem faz esses maus empresários que fazem esses desvios via offshore, geralmente o fazem com uma boa assessoria jurídica, às vezes não só no Brasil, como fora do Brasil também. Todos sabem que existem aqueles paraísos fiscais que eram inatingíveis. Hoje a coisa mudou muito. Então, o que é decidido aqui no Brasil por juízes nos processos mencionados, eles são facilmente localizados até dentro do Brasil mesmo, pela remessa. Agora, eu, na qualidade de administrador de algumas falências e, no caso de recuperações, ao ver esse tipo de desvio, hoje nós conseguimos ter escritórios aqui no Brasil especializados nesse tipo de matéria. Porém, já tive casos que nós fomos até em outro país, buscando na junta comercial daqueles países documentos e conseguimos localizar. Agora, em relação das jurisdições específicas aqui, que estamos nos referindo, que seria Jersey e Dubai, eu gostaria de saber se as ordens determinadas por um juiz daqui, elas são cumpridas pelos juízes de lá, no caso de uma decisão, no caso também de liminares, se elas são acatadas, ou há necessidade de passar por um crivo no judiciário desses países. E se, no caso de falências, onde não haja ativos para suportar com as despesas desses processos, eles acolheriam o que nós chamamos aqui de justiça gratuita, se eles teriam como cumprir as decisões sem que haja um pagamento. E se essas determinações deveriam ser cumpridas através de uma carta rogatória nesses países ou através de um outro sistema, via Ministério das Relações Exteriores ou outra forma que tenha especificamente no caso de Jersey e Dubai. Essa é a dúvida que acredito que nós temos, porque Jersey é um pouco já mais conhecida, Dubai é recente ainda em termos de investimentos. E se as empresas que lá foram constituídas para ficarem com esses ativos que foram desviados do Brasil e para lá encaminhados, elas sofrem sanções naqueles países, em razão das sanções impostas aqui pelo Brasil, ou elas são isentas disso? Muito obrigado.
Agradecendo as manifestações do Dr. Manuel Ângulo Lopes, passa a palavra à advogada Sarah Sheffield, sócia do HFW em Dubai.
Good morning, everyone. It's my pleasure and honor to be here for the first time in Brazil to speak with you today at this very prestigious event. So thank you very much for having me, and thank you to the organizers as well. I just want to make a couple of points before I launch into discussions around freezing orders and enforcement of judgments and asset tracing in Dubai. Just to give you a bit of a flavor of the way the legal system in Dubai works, in case you're not too familiar with it already. The first point that I wanted to make is that the UAE in general is very much a developing legal jurisdiction still. There has been a wave of new laws that have come into effect in the past couple of years, and also a number of new courts that have come online as well that can assist with asset tracing requirements. And a lot of the laws that I'll talk to today have come into place in the last 2 years, some of them as recently as the past couple of months, and I'm sure that if I was back here in another 6 months that there would be a whole lot of new laws to tell you about as well that might be of some assistance. Some of those relate to, there's new bankruptcy laws, there's new anti-money laundering laws, laws to do with ultimate beneficial ownership, the way in which companies domiciled in the UAE can be owned. Previously, it's been restricted to majority shareholders being local partners, but now there's a move toward 100% foreign ownership. And also substantial changes to the civil procedures regime, which is hopefully going to have the effect of making civil proceedings much faster and much more streamlined, because to date, proceedings before the local courts can be quite cumbersome. And the second point that I just want to make is to explain a little bit about the different legal systems that we have in the UAE. And that's something that's probably a little bit unique about the UAE, the United Arab Emirates. And that's that it has both a civil law system as well as a common law system that run side by side together. And how this works is that there are 7 emirates that make up the United Arab Emirates, and each emirate has its own emirate or state court. And they all form part of the civil law system, and they apply UAE federal law and also Emirate law as well. Proceedings before those courts are conducted before civil law trained judges in Arabic, and often with the assistance of a court-appointed expert who carries out much of the work. And there's also no concept of binding precedent in the local courts as well, which can be challenging in terms of one case to the next, in that what might have happened last week might not necessarily go the same way than the following week in a different case of a similar nature. In addition to these state courts, in 2 emirates, and that's Dubai, where I'm based, and also Abu Dhabi, which is the capital, there are separate financial free zones called the Dubai International Financial Centre and the Abu Dhabi Global Market. Those are separate legal jurisdictions which are subject to a separate common law system. They have separate courts which are entirely distinct from the local courts. They apply DIFC law and ADGM law, which is derived from English law. Proceedings are conducted in English before common law trained judges, which are coming from a variety of common law jurisdictions around the world, including the UK, Australia, Malaysia, Singapore, for example. And those courts are essentially modelled on the English commercial court. The DIFC has been up and running for a while. It was established in 2004, but the ADGM court only came online in 2016, so it's still developing its case law. In terms of the jurisdiction that they can exercise, they have jurisdiction over civil and commercial matters, but not criminal matters. Anything criminal is still reserved to the local court system, the civil law system. And you can establish jurisdiction in the DIFC or the ADGM by a number of ways, including where one of the parties is an established entity within those jurisdictions, or where there has been a contract that has been formed or executed or performed within the geographical limits of those jurisdictions, or also, most importantly, where the parties have chosen to opt into those jurisdictions. So that means that any party anywhere around the world can choose to come to those courts to have their disputes resolved, and they needn't have any connection to those jurisdictions otherwise to utilise the court services. So the reason for explaining the difference between the 2 different types of court systems and laws is that when it comes to asset tracing, we need to know which court we're going to be operating in, and they also operate side by side in many respects as well. And the remedies and procedures that are going to be available in each jurisdiction will depend on which court you're operating in. So in terms of the main tool that we have in the UAE generally in aid of asset recovery proceedings is the freezing injunction or the freezing order. If you had a Brazilian freezing order, unfortunately, you can't directly enforce that in either the UAE local courts or in the DIFC or the ADGM. But thankfully, that's not the end of the story. Otherwise, we would be having a very short conversation today. What you can do is commence fresh proceedings in either court for a freezing injunction. And as a part of those fresh proceedings, you could submit your Brazilian freezing order to the UAE court in that process to help establish a basis for freezing assets. So assuming you are going to be pursuing a target that is in the onshore court, so outside of the DIFC or outside of the ADGM, a claimant or creditor can apply directly to the relevant emirate court for a precautionary attachment over assets. And that can be done either prior to the commencement of substantive proceedings or afterwards. The assets that can be attached are very wide-ranging. It's anything movable or immovable, so it covers bank accounts, shares, vehicles, equipment, money and bank accounts. And importantly, you can also actually attach a company's trade license, which is something that is often overlooked, but it's a very effective method of freezing a company because it effectively means that they're unable to trade while that freeze is over their trading license. Assets that can't be attached are just limited to public funds belonging to the UAE or to a particular emirate, and also funds of foreign governments, foreign embassies, also things like alimony and inheritance and things like that. But otherwise, it's fairly wide-ranging. Now, in the local court system, an attachment order will only be granted by the court in two circumstances. If it's post-judgment, it's very straightforward, and that will be put in place very easily. It's more difficult, however, if it's a pre-judgment attachment, and in that case, you'll need to demonstrate that the debtor has no permanent residence in the UAE, and that you fear that the debtor is going to escape or try and conceal or smuggle their assets, and that there is therefore a risk of dissipation. That's a fairly high threshold to meet, and it's likely going to be more difficult to establish in circumstances where there is a long-standing onshore limited liability company that is your target. And also in respect of even if it's a foreigner, an individual who is your target, if they have residency status in the UAE, it's going to be difficult as well. It's difficult to establish that they're going to be a flight risk. However, it is more straightforward to establish that there is a risk of dissipation of assets if a company is 100% foreign owned, which is possible in the UAE. We have various free zones at the moment where that's possible in the onshore system. Or alternatively, where the trade license of the company is about to expire. And also if there's evidence of what we refer to as phoenixing, which is a quite typical practice in the UAE carried out by debtors trying to conceal their assets, whereby they effectively close down one company, strip the assets and transfer it to a new company and open up trading with the idea to defeat their creditors. So if you can demonstrate any of those things, you're going to be a much better ground to have your precautionary attachment put in place. So the way that is done, you need to submit your application to the local court. This is all done in Arabic. All your documents will need to be translated into Arabic language. You would use a very wide language to make sure that you're covering all movable and immovable assets. And in this respect, it is actually somewhat of a fishing expedition in the UAE, because you don't necessarily need to specify particular assets that you are looking to attach. It is, of course, very helpful if you do, and there are various ways that I will come on to shortly to explain how you might get a little bit of information about what is out there. But otherwise, it's not necessary to specify that in your application. And you'll also need to particularize your case as well in terms of the factual background to the matter. If you have proceedings already ongoing in a different jurisdiction, it's very easy just to almost replicate that. In the UAE court system, the judges don't like to see anything more than 1 to 2 pages, so it makes our job much easier in terms of preparing a pleading. And of course, you'll then submit your Brazilian freezing order as a supporting document as well. Once the court has received that, they'll render a decision in about 3 to 7 days. That's all done on the papers. There's no oral hearing. There's no appearance before the judge. And during that time, the court might carry out some investigations to establish that the assets, if you have named them, do actually belong to the debtor who is being targeted. And an applicant might also be required to put up some security in support of their application as well, which generally is around 10 to 25% of the value of the claim. The good news is that once the court makes, and assuming the court makes the attachment order, it then essentially does a lot of the hard work for you. And the reason for that is because the court then writes to the central government authorities, requiring them to put information, to provide information back to the court. That includes, for example, the central bank, the land department, et cetera, and they will implement the freeze. Even if if an attachment is put in place, you will then have to substantiate that attachment by way of a substantive case to keep it, to maintain it up until the time that a final judgment is reached. If you have proceedings ongoing in Brazil, for example, at that point you could file your substantive case so that you've met your technical requirement to keep the attachment order alive. And then you can apply for a stay of the substantive case until such time that you have a Brazilian judgment, at which point you can then substitute that in to turn the precautionary attachment into a final attachment and then proceed to execution. Alternatively, if you're in the DIFC court, it follows a fairly similar approach. The courts there can also grant freezing orders in aid of foreign proceedings. The test, you'll need to show a more stringent test before the DIFC courts, being a common law system. You have to show that you have a good arguable case, that there is a solid evidence of risk of dissipation of assets by reference to an unacceptably low standard of commercial morality on the part of the defendant, and that in all the circumstances it's appropriate to make that order. That application is again filed before the court, but this time in English with your supporting material. You will be required to put forward an undertaking in respect of any damages that might be suffered by the defendant in the end that the order is not sustained. And then that will proceed to an oral hearing before the judge. Alternatively, if you have a judgment already, I just will run very quickly through the ways in which you might bring a Brazilian judgment into the UAE. There's different options. If your assets are based in the onshore system, in the DIFC system, you can proceed directly to that court and make an application for recognition and enforcement of your Brazilian judgment. That's relatively straightforward. There's very narrow grounds for defending that application, which are limited to things like offending the public policy of the UAE. And once that is converted to a DIFC court judgment, you can proceed to execute against assets based in the UAE, in the DIFC. Alternatively, if the assets are based in the onshore courts, there are two available options to you. The first one is that you can proceed directly to the onshore courts, and there have been some significant changes in the procedure recently whereby you now proceed directly to the execution court and file your application there. Previously, you had to go through a number of layers of the court from the court of first instance up, which took a long time. You have to show all the usual requirements, like the Brazilian judgment is a final judgment. It's been entered in accordance with Brazilian law, for example. But there is one complicating factor here, which is under UAE law, if the UAE court considered that it could have had jurisdiction, or that it did have jurisdiction to resolve the dispute initially or prosecute the claim, then it will refuse. It can either refuse to enforce the judgment, or it will simply proceed to redetermine the matter from scratch, which can be a time-consuming process. So in that circumstance, you might actually, because of the way you establish jurisdiction in the UAE courts, instead of proceeding to get a Brazilian judgment, it might be preferable just to come and bring your claim directly in the UAE courts first to avoid having to go through that extra layer of process. The second way of bringing your judgment into the UAE against assets based in the onshore jurisdiction is actually to come through the DIFC court or the ADGM court in a way that has emerged as a conduit jurisdiction. What happens there is you make your application for recognition and enforcement of your Brazilian judgment in the DIFC, and your Brazilian judgment is converted into a DIFC court judgment, and then it is then passported into the onshore jurisdiction under a protocol that is in place between the DIFC courts and the Dubai courts. And the main advantage of that process is that under that protocol, the local Dubai courts are not permitted to look into the merits of the judgment that is being enforced. So you won't come up against the same problem that you might come up against if you go directly to the local courts. In terms of identifying people who might be responsible for losses, people that you might want to target, where the assets are held, there's various ways of going about evidence gathering. Some that are very simple and straightforward and inexpensive that don't involve the use of the court, and then others that do invoke the assistance of the court. For example, you can apply for a Dubai Chamber report from the Dubai Chamber of Commerce, which will set out the shareholder details, directors, auditors, often the bank account details of the onshore company. Alternatively, you can apply to the Dubai Economic Department for a copy of the company's trade license. Now, that is only available in respect of onshore companies, but you will get details of the shareholders and manager of the company, and the manager is very important because they're the ones that have ultimate control over the company. Alternatively, and I'll be very quick, various applications that you could make to the court for assistance include applications to the court to appoint an expert to go out and conduct inquiries on your behalf, either with the defendant themselves or with third parties. For example, auditors, banks, for example, to compel them to deliver up documents and information to you. And those methods are also available in the DIFC court as well. And I think that's all I have time for. Yes.
Agradecendo também a participação da Sarah Sheffield, passo a palavra para o último expositor desse painel, Stephen Baker, sócio do Baker & Partners em Jersey.
Can I just start by thanking Rodrigo for my invitation to speak at this conference. It's a fantastic conference, and I think we're all working towards a really great purpose. And I think that whatever happens today will make a difference because we're all going to try different ways of recovering assets for Brazil. The questions that we've been asked in the last 45 minutes could take a couple of days to answer, and I've got 15 minutes. So I'm going to try and answer as many of them as I can. Otherwise, my email's available, and like the judge beforehand, I'll answer all emails and all approaches. My friend asked a really straightforward question, which is, what are the best means of recovering assets? What's the best way to do it? And I'm going to give you a typical lawyer's answer. That all depends on the facts of the case. But today we're focused upon civil asset recovery, so using civil process to recover assets and including insolvency. So that's what I'm going to focus on. An initial point, don't mistake each offshore center to be the same as the other. They're not all the same. You just heard a talk from Sarah about Dubai, which was hugely informative. But the Dubai system is completely different to the system which applies in Jersey, which is very similar, though little differences, to the system I anticipate you'll hear about in the British Virgin Islands, which is similar, though with differences, to the Cayman Islands, but which is completely different to Panama or one of the Central American offshore centers. So really do not think about offshore centers as one. They're very different, and you need to think about them differently. I'm going to run through the basic disclosure and asset recovery tools, which there are in Jersey, and then I'm going to make a comment and try and go into a bit more detail. The basic tools which are available in my jurisdiction include disclosure orders against banks and trust and company service providers. So before proceedings are issued anywhere in the world, in certain circumstances, you can get disclosure of information from Jersey banks and other financial institutions. What do you need to prove to get it? Well, you can't go on fishing expeditions, that's right. But if you can show some evidence that you might have been victim of a wrongdoing, that includes fraud, but it includes all forms, or almost all forms of civil wrongs, then if you can show that it's necessary in the interests of justice to have disclosure from the bank or trust company, then the court will order it. We do this all of the time. We've done it with Rodrigo in the last year, and we're doing it in a Brazilian case now. So you can get disclosure even before proceedings are issued anywhere, because you need to know the information in order to work out where you've got a claim and who to sue. We have freezing orders, like Sarah described. They're applied in different circumstances. You can get a freezing order even before proceedings are issued anywhere in the world, though you need to issue proceedings fairly quickly thereafter. You can get disclosure orders with the freezing order, which orders banks and trust companies to disclose the information they have so that you can check that the freezing order isn't broken. You can get gagging orders, orders which prohibit the bank or trust company from telling anybody that you've got the order, so that you can go ahead and trace the assets. It's no good getting a disclosure order in Jersey and you find that money's moved from a Jersey bank account to Switzerland if the bad guy's going to find out straight away that it's in Switzerland and can move it from Switzerland. But we've used gagging order recently to get a Jersey disclosure order which revealed that there was money in Switzerland. We got secrecy orders, gagging orders, and we were then able to instruct lawyers in Switzerland who froze the assets in Switzerland, and the money which was in bank accounts went back to the victims. Another great tool is actually issuing civil proceedings in the offshore court. So if you can find somebody who's responsible for the fraud, or who may be responsible for something which means there should be a lot more money in the insolvency estate than there was, then think about issuing proceedings there. So if a bank has been responsible or closed its eyes to a company running itself in a way which is completely insolvent and in fact might be a fraud, then think about suing the bank that caused the loss, and then you would generate, you may generate, if you win, assets which go into the estates. I can answer one question immediately. You can't do this for free. There is no free service, so that's good news for lawyers, but not so good news, I'm afraid, if you're looking to have it done for nothing. I think you need to start again if you think it's going to be done for nothing. So those are the overall tools that, as I see them. I can tell you it's doable because we've done it, and we do this regularly. And I've had the great privilege to act for Brazil and Sao Paulo for many years, and we've done it for them. We sued 2 British Virgin Island companies for being dishonestly involved in a very famous Brazilian fraud, and we won, and we recovered assets, and we're still recovering assets. So it can be done if there's the will to see these things through. So that's an overall picture. I want to turn, if I can, to recognition of Brazilian judgments and Brazilian orders in Jersey. Let's start with the freezing orders. If a Brazilian judge issues a freezing order in Brazil, the Jersey court will almost certainly make an order which means the Brazilian freezing order is effective, technically, we cannot just recognize the order of the Brazilian court, because usually it's not a final order. So you need to make a fresh application, and there will be a freezing order made in my experience. So we've done them for Brazil. We've done them for the tax haven of Monaco in the south of France, which is a very different tax haven, I can tell you that. We've done them for African countries. We've done them for Russia. So this is it's a staple part of my legal life, is getting assets frozen because foreign courts want them to be frozen. We can even do it for jurisdictions which don't even have a freezing order before, certainly freezing orders before proceedings are issued. We can freeze assets before proceedings are issued. You can't generally do that in lots of countries, like the United States, for instance. You can't do it there. But that won't stop the Jersey court freezing assets if it thinks that it's needed in order that when the case finishes, the judgment of the foreign court can be enforced. So I can say that as a matter of policy, my courts, the Jersey courts, are keen, particularly where there's been a fraud, to make sure that assets are secure. And that includes assets held through companies and held through trust structures. And I'm going to say a little bit about trust structures in a moment. Brazilian final judgments will be enforced in Jersey under the common law. There's no statute or legislation which enables it. The Jersey statute, which deals with enforcement of foreign judgments, has very few countries in it. We can enforce judgments for Australia, Sheffield, Sarah, so you'll be pleased. We can do it for England and Wales. For reasons I have no idea, we can do it for Finland. So Finland's on the list. I'm not aware of any Finland judgment ever being enforced in Jersey, but they can do it under the statute. But every other country in the world, we will look at enforcing judgments on the basis of comity, using the common law to enforce judgments. There's no formal requirements of it having to go, under our law, of it having to go through diplomatic channels. If your law says it has to go through diplomatic channels, then that's a matter for your law. In Jersey, the plaintiff, the person that has the benefit of the order, can just come to court and have the judgment recognized and enforced. And again, we do that regularly. It's a regular part of our practice. I've been told I've got 5 minutes, but I think you want to hear a lot longer, so I'm going to talk for 50 minutes and see what this lady does when I get to about 45 minutes. So we can enforce Brazilian judgments. Let me talk about trusts, because I know that you're all interested in trusts. I'm not pretending that trusts are easy. I'm not pretending that. But if, for instance, you can show that assets have been transferred into a trust while somebody's being insolvent, which is very often the case. It's not unusual for them to think, oh my goodness, my business is looking very, very dodgy. I better settle it into a trust. That's no good. The Jersey court will reverse all of that. It'll just look at it and say that's not a proper trust. We're going to take the money that you've transferred into the trust out of it. And trusts, it's a bit like magic, isn't it? It sounds like it's some crazy magic thing, right? But once you understand how they work, there are various ways to deal with them. So the trust, you can reverse transactions which went into a trust. Trusts always, in my experience, hold shares in underlying companies. So you'll have a trust at the top and then companies underneath. If there's been transfers into the companies underneath the trust, then the same principles that you're all really familiar with apply. If it's been transferred without value, if nothing's been given for it, why was it transferred? If somebody was insolvent when he did it, why was it transferred? The big mistake that people from overseas make in relation to offshore trusts, in my experience, is just saying, it's a sham, it's ridiculous, it's crazy, these common lawyers have gone mad. and they've invented something which is just nonsense. Unless you've got all of the assets that the trust holds in your jurisdiction, so that you've actually got, your judge has got control of them, and you're really sure that the judge is going to go, are you sure there's not somebody else that's got an interest in this? Don't argue sham, because it's hugely difficult to prove. You've got to prove that both the person that paid the assets into the trust, that moved the assets into the trust, and the trustee himself are dishonest. Now, you may think all offshore trustees are dishonest, right? If I asked for a vote, I bet most of you would say you do. Well, a local court's never going to decide that a local trustee is dishonest. It's very, very, very unusual. I don't think I've ever come across it. So don't argue sham. You need to look at things in a much more sophisticated fashion than saying sham. So reversing transactions is the most straightforward one. But also, particularly these days, you need to read the trust documents really carefully. So you need a disclosure order to get the trust documents, which you should be able to get. And then you need to read them really carefully, because very often the set law, which is just jargon for the person who paid the money into the trust, will have reserved powers to himself. And if he's kept a power for himself, you may be able to get control of that power. So if you're an insolvency practitioner in Brazil, you may be able to get control of a power, for instance, to revoke the trust. And that's been used very, very successfully in the Cayman Islands. And there are other really technical and fairly complicated matters of trust law which you can sometimes use to get behind the trust. So you need to instruct a lawyer that knows lots about trusts, that's what I say. But I would say that, right? Because I'm a lawyer that knows quite a lot about trusts. I also want to just comment on beneficial ownership of companies, because that's been raised. In Jersey, you can usually get disclosure of the beneficial ownership of the company. You need to get a court order to do it. But the Jersey Company Registry, for the last 20 years or so, has been keeping pretty good records of who the beneficial owner of companies are. It's a crime to lie to the registry. And they have a system of regulating trust and corporate service providers. So just as I imagine your banks have a regulator, maybe the central bank, that regulates the banks and can go in and check their following procedures, so Jersey has a regulator that checks that the trust and corporate service provider companies are keeping proper records, and it's an effective regulator. I think I've said all that I want to. There was one early question about what a Jersey court, how a Jersey court would consider local creditors, and actually, to be honest, I need to check that, because it hardly ever arises when there's a foreign insolvency. It's not the nature of the Jersey business to have local creditors. Yes, you have to advertise in the local newspaper for local creditors, but I don't think I've ever heard of a local ever come out other than in a local insolvency. So it's not a problem that we particularly have to deal with. And I promise I'll stop in 1 minute. There's one more thing I need to say. On insolvency cases, it's relatively straightforward to get the Brazilian insolvency practitioner recognized in the Jersey court, and that is happening all the time. Foreign insolvency practitioners are recognized by the Jersey court. There are local quirks, local oddities about the application, but they recognize the overseas insolvency practitioners. Again, Rodrigo and I are doing one at the moment. And you will be given all of the powers that you have in Brazil, in Jersey. And it may be, that's right, all of the powers that you have in Brazil, you will be given in Jersey. So you will be able to interview witnesses, call for documents. You can have instructions on bank mandates changed so that you take the mandate. You can sack the shareholders of companies. You can replace the boards of companies with your appointees. It's a very, very powerful tool in the right circumstances. So don't believe that offshore is just a place where money disappears. True, lots of money does disappear offshore, but there's lots that can be done to trace it, to follow it, to freeze it, and to do that with secrecy orders. So if I can leave you with one message, it is there is lots of information offshore available for you to get. So try and get it.
Agradecendo o pronunciamento do Dr. Stephen Baker, antes de passar para a moderação, debates, eu agradeço a presença do juiz Marcelo Sacramone, que por necessidades de outros compromissos terá que se retirar. Na qualidade de moderador, como se trata de matéria muito específica, de comum acordo com a direção do IBRA, formulamos algumas perguntas para cada um dos palestrantes, para que possam esclarecer alguns detalhes. Com relação ao Dr. Lucio, Angelo, Júnior, da AGU, eu indago se uma das grandes preocupações da AGU são com os recursos desviados por corrupção e por crime fiscal, por se tratar de crédito de natureza tributária, quais dificuldades que a AGU tem enfrentado no cumprimento de ordens de bloqueio de bens que se encontram fora do país?
Obrigado, desembargador. Eu vou ser breve na minha resposta, apesar de não trabalhar diretamente com matéria criminal, como eu expus anteriormente, e a questão da própria matéria tributária ela não ser afeta ao nosso departamento, eu acredito que elas compartilhem das mesmas nuances no momento em que a gente vai pedir auxílio à jurisdição estrangeira. E hoje o grande problema, eu acredito que isso pode ser resolvido com bastante diálogo, são a falta de compreensão da jurisdição estrangeira acerca das particularidades da legislação brasileira. Estava discutindo ontem, eu não sei se o Jack está aí, né, dos Estados Unidos, e a gente estava falando, por exemplo, no Brasil nós não temos uma lei de extinção de domínio, por exemplo. Entretanto, nós temos outros instrumentos jurídicos, como a ação em reverso do próprio Código, previsto no Código Civil, em que a gente pode atingir diretamente bens quando houver o enriquecimento ilícito. Mas levar isso para a jurisdição estrangeira sem uma base legal que seja compreensível ou minimamente que tenha sido tangenciado em algum momento por aquela jurisdição específica, nós realmente não conseguimos ter um reconhecimento judicial. Hoje, na perspectiva da AGU, em se tratando de crédito público, nós estamos ainda começando a aprender com os practitioners da advocacia privada caminhos alternativos à cooperação formal, né? O colega Fernando vai falar daqui a pouco disso também. Estamos começando a ver quais são os meios eficazes para fazer com que, independentemente do tipo de procedimento ou da legislação, como o próprio conceito de improbidade já é bastante difícil de traduzir, né? As autoridades estrangeiras ou juízes estrangeiros a cargo do enforcement dessas decisões ou a cargo de algum tipo de reconhecimento, né, de ilícito, ele possa ser sensibilizado acerca dessas particularidades, mas que ele tenha a noção de que se trata de uma decisão, seja no âmbito criminal, civil ou administrativo, de uma decisão oficial de Estado. Ela é uma decisão que vem do governo brasileiro, de um governo soberano legitimamente constituído, de uma democracia. E por que eu digo isso? Porque não necessariamente ficar adstrito só à decisão judicial, mas há atos sancionatórios legalmente conduzidos de acordo com as premissas do devido processo legal, da ampla defesa. O acordo de leniência, eu acho que é o grande baluarte do momento, em que são passíveis de reconhecimento, mas hoje eu acredito que esse passo à frente ainda não foi dado. Então, desembargador, agradeço a pergunta, eu acredito que diálogo é a solução. Agradeço a organização do evento mais uma vez por dar essa oportunidade da gente compreender como funcionam as jurisdições estrangeiras e cada vez mais refinar o nosso conhecimento, porque estamos tratando muitas vezes de casos multilaterais. Vai envolver 2, 3, 4, 5 jurisdições. Já peguei casos com 10. E é bastante complicado a gente endereçar isso tudo de uma maneira adequada. Mas eu acredito que o diálogo seja a melhor saída ou seja, vamos em frente, né, para ver como é pertinente essa proposta do IBRA de dar continuidade. Se pudermos ter mais encontros, vai ser um prazer sempre poder ouvir dos senhores. Obrigado pela pergunta, desembargador.
Obrigado. Eu teria mais algumas questões, talvez, a propor aos demais palestrantes, mas, em virtude do adiantado da hora, vou acabar encerrando o painel e agradeço a presença, mais uma vez, do Dr. Lucio, Alves, Angelo, Júnior, doutora Danielle, promotora do DF, Dr. Manuel Ângulo Lopes, Miss Sarah Sheffield e Mr. Stephen Baker. Muito obrigado a todos. Está encerrado o painel.